Now, reporter Moloko Moloto was at court this morning and he joins us now here in the studio. Moloko, what are the implications of this going forward? Another bloody nose for the public protector. You can't look at it in any other way.
Well, Marcel, long before the judge could even hand down her judgment or makes her order clear, it was apparent that the writing was on the wall already, that it was going against the public protector. Her argument, that is the judge, was that it's mind-boggling for the public protector to oppose, particularly the one aspect of the president's application, one that relates to him asking for the court to temporarily suspend implementation of the remedial action. And the judge was saying that it was the public protector through several correspondences, letters that she was writing to the president, advising the president that if you are not implementing my remedial action, you cannot simply ignore them. Rather, seek get a court order to interdict my remedial action. Now, in court, she was arguing that it is not the president who must do that. It is the minister who must interdict the president. Now, the judge was saying that's unreasonable because by suspending the decision to discipline Minister Gordhan does not harm the public protector in any way, because she said the president in his court papers never pronounced himself in terms of saying that he thinks that the public protector's findings against the minister were wrong. However, the president did say that he doesn't think that the judicial review application by the minister was frivolous. So indeed, the implications, at least in this case, for the public protector and that punitive, because as much as the cost order were awarded in favor of the president, they are not personal cost orders against the public protector. It is the institution as well as the EFF who are going to pay those costs.
Now, I asked Alfred Mhlongo about that cost order because obviously this is one of many that's been handed down over the last little while, the last few months as it were, and he made a point of then saying, I need to address this because it's not like we are entering into these legal battles without giving it thought. We're doing so strategically with proper legal strategy, etc., etc. But to the ordinary South African, it sounds like this very important government institution or Chapter 9 institution just seems to be being hit by cost order after cost order.
No, absolutely. Perception does certainly matter. But maybe moving away a little bit from the recent court judgments that went against the public protector, we should also remember that she did win about 2 court judgments where people had taken her reports on judicial review, and 2 reports that were taken on judicial review were granted against her. So it's a 2-2. Now, when it comes to judgments relating specifically to when she was opposing urgent application, it's one where the minister, Pravin Gordhan, took her to court, seeking a court order specifically related to a separate matter of SARS rogue unit, or so-called SARS rogue unit. That was awarded, I think, a week or 2 ago. And there was another case involving a horse-raising organization, but that one the public protector did not oppose when they were seeking court order to interdict her findings. So the court also today made reference. In fact, even during the hearing last week, the lawyers for Minister Gordhan and the president were arguing that there's a precedence already. There are about 2 judgments handed down by the very same court wherein they agreed that if there's a review application, it only makes sense that the findings of the public protector are temporarily suspended. However, the argument on the side of the EFF, as we heard, is that there must be an exceptional circumstance wherein somebody must take the public protector's remedial action seeking to interdict them. So it's a catch-22 situation, really, because the president says he was forced by the public protector to go to court, because if he was not complying with exactly what she wanted, she accused him of violating the Constitution, and he had to resort to the court, and the court agreed with it.
Now let's look at the role of the judiciary just for a second before I let you go. The EFF, again, not mincing their words, about the judge put on that case, criticising her quite heavily, as they did with the last one. They seem to believe there's a pattern. They, correct me if I'm wrong, you covered it. The last judgment that was handed down, the EFF said there was a racial issue involved in that judgment and accused the language that the judge was using at the time. This judge used the term mind-boggling when referring to some of the contents of this latest report from the public protector. The EFF not mincing their words in believing that they and the public protector is being hard done by the judiciary as a whole.
Well, we all know if the presiding officer in today's matter was white, the EFF certainly was going to say she was racist. In this case, she is black. They certainly tried to...
he said that she struggled to read her judgment.
Yeah, essentially, he was suggesting that she probably is incompetent. Of course, that's not what he said. But the fact that they think that she got it wrong, the same way they think the judge in the previous matter in the same court got it wrong, and they're taking both to the Constitutional Court, as they say. However, the argument that the perhaps judiciary is against the public protector, that doesn't hold water, because if that is the case, then are we all therefore saying that the majority, remember in the Constitutional Court, where the judges ordered that she must pay 15% of the cost, I mean, 8 out of 11 judges found that she was wrong, and even the minority judges, Mogoeng and Justice Goliath, as much as they did not agree that she must pay the personal costs, they actually poked holes in her argument throughout the litigation. Now, that doesn't hold water. The fact of the matter is that here we have the public protector who seemingly is not even seemingly, clearly is getting her facts wrong. And the question now is that if she is going to the Constitutional, if she were to go there, is she prepared to go through the same process? Because the courts of the judges of the Constitutional Court were essentially saying that personal cost orders are awarded to officials who basically are careless.
Gosh, we're going to have to leave it there. Loads for you to keep an eye on, yet again, in this latest development. Thank you so much. Our reporter Moloko Moloto with the very latest on that case involving the public protector.